In a civilized society, a man cannot live without the right. There are many rights available under the general law as well as under the special law. Now, question arises that what is a right? So, right is a protected interest. Right is a power which is given under the law to somebody, and if someone takes away that right, એ હકને જો કોઈ છીનવી લે, એની પર તરાપ મારે, then for that the remedies are available in the court of law. And such remedies which are recognized under the law, they are on the civil side as well as on the criminal side. Even apart certain special remedies which are available in case of infringement of some special rights which are called as a fundamental rights under the Constitution of India, and such remedies can be available under Article 32 as well as Article 226 of the Constitution of India. And such writs are divided, or it has some 5 parts in giving the writ direction by the High Court or Honorable Supreme Court. Now, such writs may be called as a writ of quo warranto, writ of certiorari, writ of prohibitory, writ of mandamus, and a writ of habeas corpus in case when a person is not found out till unknown in kidnapping or other way, then such types of special writs are given with the direction to the state or to the police to find out such a person and have a body of such person before the authority or before the court. Now, such types of rights and the remedies. Now, there are no rights without any remedy. It is said that where there is a right, there is a remedy. And there is no right without any remedy. So, in case of infringement of any right arising out of a contract or otherwise, at that time, a proper remedy is available in a proper forum, that may be court or other authority. Now, here for the students of law, those who are having preparation for the examination and those who are going to appear in third law, and particularly when there is a subject for them, it's on the moot court, which has been introduced by the Bar Council of India, say after in the year 1997 or 1998 thereafter, that students to be given a practical knowledge prior to coming to the regular judicial courts. So moot court is artificial court. It's imaginary. Some imaginary or hypothetical cases are to be discussed in a law institute, in a special room or in a special hall. Some arrangement is made so that some atmosphere is created so that the student can argue the particular case. So that when they come to the regular court, then they will not feel some fear, or there will not be any new atmosphere for them, because they have already learned the procedure and the atmosphere in the institution itself. So, looking to that base, I am giving 2-3 illustrations so that the student of law can prepare the arguments based on a moot court or a mock court. Now, here I am having one illustration relating to the money suit. Now, in case when the amount is not paid to a seller who is called as an unpaid seller under the Sale of Goods Act 1930. Apart from that, in some routine transactions also, when some contract is made and there is infringement of the contract, or other party is not in a position to fulfill his part of the contract, at that time what is the remedy available under the Contract Act? So Contract Act provided many remedies in case of a breach of a contract, as for example injunction or damages. Over and above, some special remedies are recognized under a special law. Now here in one example that Mr. A on 1/1/2018 he has ordered for 100 tins of eatable oils from Ahmedabad. The seller of Ahmedabad, on telephonic talk, he has fixed the price rupees 3,000 per tin. Now what is the contract? That Mr. A of Baroda has ordered for 3,000 eatable oil from B of Ahmedabad, and price which was fixed on telephone was rupees 3000. This is a fact. Now the price is fixed and the quantity is fixed, so the value is 3 lakhs, and as per their talk, Mr. A from Baroda has to pay some advance amount to B against the total bill. Here, in this case, that rupees 1 lakh advance amount by way of check was given by A in the account of B, and B has already within 10 or 15 days delivered the goods, and the goods are reached to the godown of Mr. A. Here there is no dispute. Dispute starts when B has given the bill, and that bill was reached to Mr. A. So I called Mr. B that why you have given this much bill when the price is fixed rupees 3000 and you have billed per tin 3300, 3300. I will not pay. The B told that on telephone the prices were roughly fixed. Now, as per the change of the market, today the value of one tin costing rupees 3300 in Ahmedabad, and some transportation charges like that he has billed it, but A refused to pay. B has issued a notice about recovery of money for which the goods are sold, being an unpaid seller. Secondly, B has also sued for damages and the reputation in the market. On that ground, he has fixed some amount of 3,50,000 for which A is required to give him to B. So B has issued a notice. A has replied to the notice. No settlement can be made on telephone or otherwise. So B decided to file a suit in the court of Ahmedabad. Now, B intends to file a money suit in the court of Ahmedabad, and the value of the suit was rupees 3,50,000, including interest, cost, everything. Now the suit is framed and suit is filed. Here is one illustration. Now how to represent this particular issue before the court. When this issue is taken to the lower court, then in the lower court the witnesses will be examined from this side and that side. Documents will be put up, and and after completion of the arguments and all, the court will give the judgment. But in a moot court, when the students is required to argue, then in such a case the students has to argue on a legal point. Not on that the witnesses are examined, cross-examination made or re-examination made, not like that. That procedure is not followed in such courts as I think. But at appellate, when a lawyer arguing in appellate court like that in this moot court, the student has to argue and prepare his case study on the basis of the legal points and legal arguments to be put up by his own case, by any imaginary case or otherwise. So this is one illustration is given to a student. Now here in this case, what are the points which will come out in the mind of a lawyer of one side and points in the mind of the other side? Now one we can say that the case of the plaintiff, वादी के जे अपना unpaid seller से अहमदाबाद भाई, the plaintiff will come to the court and say that I have been given the legal order on dated so and so. On that basis, legal agreement, legal contract, and as per the words of Mr. A, who is a reputed businessman of Baroda, and I know him very many years. So I have sent 100 numbers of tins to Mr. A. He has also given the advance amount of rupees 1 lakh, and on that basis I will sell the goods by truck. And he has received the challan number issued, signed by the agent of Mr. A. So there is no dispute till then. But the dispute arises as to the amount. The prices are increased and the price raised to 300 rupees per tin. So it was denied by Mr. A. In the court, Mr. B as a plaintiff submitted to the court that there is a condition in the bill that the latest price will be as per the market in Ahmedabad day to day, and in case of any dispute, the jurisdiction will be at the Ahmedabad court. So on this ground, the bill is prepared as the recent price which will be prevailing in the market, that will be considered and not the price that will be given on a telephone. That also Mr. B, who is a purchaser, he knows very well. But his impression is not proper in the market and he has no such money. So he's just lingering the matter not to pay. That is the case of Mr. B, who is a plaintiff. On the side, Mr. A, who is the purchaser of the oil tins, he submitted to the court that the suit is not proper and the Ahmedabad court is having no jurisdiction. The suit is not tenable and maintainable in law. It's a false case, frivolous case, and just to take more money from me, he has given a wrong bill. Like this is the simple arguments on behalf of Mr. A, who is the purchaser. Now, what is the defense that Mr. A, being a purchaser, has taken? First, that goods were not according to the sample. First thing. Secondly, the goods were damaged. Out of total 100 tins, some 15 tins were leakage. So he didn't get the full oil. That is also. So he claimed for a damages and goods not according to the sample, less goods like that. And the price at the time in the market, oil market, it was 2,900 and not 3,300. This is a matter of dispute. So this is the points raised by A and B. And on the basis of the evidence on record, the court will find that who is right and who is wrong. Another, the argument of Mr. A is that I have already paid rupees 1 lakh as an advance, and the claim of Mr. B some 50,000 is more. There is no terms about the interest that is to be given, and there is no loss or damage. On the contrary, there is a damage to me because I have already retrading to some other person in Surat. So the goods which are sold by B to A, has transferred the goods to Surat. So likewise, this is pure channel. That's what he wants. It is a case of defense on behalf of Mr. B. And there is a case of Mr. A. I told you that the prices are increased, and then my bill is proper. It is already delivered, and so he is bound to pay the amount. This is a case from plaintiff as well as defendant. So on this ground, and along with some recent citations and judgments of the Honorable High Court or Supreme Court, that the students can put and can prepare the whole arguments from this side and that side. Now in another case, there is a suit for possession. Now in a suit for possession, agreement to sale. Mr. A is the owner of the house in Baroda and his bungalow valuing rupees 1 crore. He has given the advertisement in the newspaper, and Mr. B has offered to purchase the house, and they made a written registered agreement. Agreement is registered as per the Registration Act. So when the agreement is registered, both the parties are liable as per the agreement. As per the agreement, Mr. B has paid 25 lakhs at the time of agreement to sale. And next amount, that is 75 lakhs, were to be paid within 4 months when he will get the loan. Now nearly before 4 months, before a few days, Mr. B called Mr. A that when he will execute me a registered sale deed. Mr. A said, I will see like this, and he has now started passing the time. So B, he was surprised that when the amount is ready, why is not taking the money? Again he called. So A told that I don't want to sell. You take your amount because I have a good purchaser and he wants to purchase this bungalow in 1.50 lakhs. Now, what are the rights? The case of specific performance of the agreement, specific performance of the contract. Part of the performance is already made because amount is already 25 lakhs is in the account of A on the sale of this bungalow. Not only that, B is ready to fulfill his part of the contract, money is ready in the bank, and the check will go directly on the account of A by the bank. So there is no fault of Mr. B. He is ready and willing to pay the money. Fault is of Mr. A that he wants to take more money, some 50 lakhs more. But it is not possible because there is a breach of contract. So this is a written express contract, written contract, registered contract, and A is infringing or not following the terms and not ready to perform his part of the contract. So at that time there will be a suit for specific performance of the contract, and the B can ask for the remedies under Specific Relief Act. So under Specific Relief Act, section 37 to section 41, 42, 43, the whole provisions are given for temporary injunction, perpetual injunction, and mandatory injunction. So what is injunction? When injunction can be granted. So here in this case, the directions can also be given by the court in way of a perpetual injunction, directing Mr. A to execute a sale deed and to give the possession of the bungalow as per the contract of agreement to sale. So in these two illustrations, there are two types of argument like this. Now, in the illustration of this house or this bungalow, the arguments from the side of Mr. B, who is the purchaser, original purchaser, who has make an agreement to purchase the bungalow, that the agreement is registered, it is written, it is signed by two witnesses, and already the amount or the consideration to the contract is already transferred from the buyer to the seller, and the prices or the consideration or the value in between both the parties is decided. So there is a consent, and the consent is free. There is a consensus addendum in between the two parties, and on that ground the agreement is made. B has fulfilled his part of the contract, A is not fulfilling his part of the contract. The third evidence, it is shown that by putting this agreement to sale, he has taken the loan of 75 lakhs of rupees from the Bank of Baroda, and the check will go directly to the seller of the house. Secondly, the owner of the bungalow or owner of the house demands more money, which is not possible for Mr. B to pay, looking to the agreement, and within time he has fulfilled all the conditions and ready to pay, but the conditions are not fulfilled intentionally by the owner. So the pay is that the appointment of the court commission to be made, and sale deed is required to be executed in his favor, and the possession also to be given to the person on payment of the full amount. On the side of original owner who demands more money, he will say that this property is not belongs to me only. My brother is also having some interest. My sister is also some interest. And without asking them, I have made this agreement. See this. So likewise, some defense is made out. Secondly, that in the market, now in area, the value is increased. So that is also one of the point of the defense raised by him. The important point that is raised by the original owner of the bungalow, he told that my cousin brother has filed one civil suit in the civil court at Nadia, and it is pending. So this is a suppression of fact. So likewise, these two arguments from Mr. A and Mr. B it should be supported with all these legal documents, and you can put up your case or arguments. And some legal issues, legal points, some legal judgments and citations on Contract Act, specific performance of the contract, and on the specific relief, section 37 to section 41, when perpetual injunction can be granted, cannot be granted, when direction can be issued by the court for appointment of the commissioner to execute the sale deed likewise. So on this ground, there are many illustrations, and in your syllabus there are many suits. So in a short time it is very difficult to explain, but these are the two illustrations, and in your syllabus there may be suit for foreclosure of suit for declaratory suit for damages, then suit for breach of contract, suit for dissolution of partnership of the firm, like that. Many suits and varieties of the suits are available under the Civil Procedure Code. The provisions are given in respective orders. Now, the procedure that is available in a court based on the civil procedure, particularly that is to be followed in case of varieties of the suits: summary suit, regular suit, special suit. Likewise, many suits, partition suits, many suits are filed. Suit may be of a representative character under Order 1, Rule 8 of Civil Procedure Code. Suits by or against the government, and when the suit is by or against the government and plaintiff is a private person who wants to seek any remedy against the government, then under section 80 of the Civil Procedure Code, a notice first is required to be given prior to any actions to be made against the government, because a breathing time is given to the government. Within that time, if the matter can be solved in that particular notice period, then there is no need to file a case. Even under landlord and tenants cases, for getting the possession, the statutory notice must in case of arrears of rent. So on the ground of arrears of rent, the landlord has to give a statutory notice of demand of rent, and tenant is not paying the rent and in the default, and then after the suit can be filed when the notice period is over. Now further, the stages of the suit, when the suit is filed, as per section 9 of Civil Procedure Code, that suit should be filed at the lowest court competent to try it. દરેક તાલુકા કે જિલ્લામાં જ્યાં જ્યુરિડિક્શન આવતું હોય ત્યાં જે નીચેમાં નીચે અદાલત છે, સિવિલ જજ સિનિયર ડિવિઝન, સિવિલ જજ જુનિયર ડિવિઝન, like in that particular court, as per the pecuniary jurisdiction, the suit can be filed even on the basis of the situation of the property, immovable property, where it is situated, then the suit can be filed. In case of plaintiff and defendant, in case of the contract, where the defendant resides or where the plaintiff resides, on that ground also the suit can be filed for the purpose of the jurisdiction. Now, for particularly about the filing of the suit, 2-3 things are very important. First of all, when the case comes, then whether this court is having jurisdiction or not. Pecuniary jurisdiction, geographical jurisdiction is or not. That first of all. Secondly, limitation. Under Limitation Act 1963, limitations in varieties of the suits are provided. That starts from 3 years, 12 years and 30 years in cases of government in specific situations. In cases of adverse possession and in possessory rights also, the period is 12 years and like that. In case of money suit, the period is 3 years. So when any contractual transaction is made, or any monetary transaction of lending of money, or say amount to be recovered from on the basis of promissory note or otherwise, when some money is involved, at that time the period of limitation is 3 years. Within that time, the claim to be made. Suppose within 3 years it is not possible for the party to file a suit, then it is a time barred. And when the suit is time barred, then no remedy is available, and therefore the amount is gone. But there is a one provision that within a span of 3 years, If either of the party, by any gesture or by say email or by message or on recording anything, when they commit about the old debt, it is called as an acknowledgement. Say for example, Mr. A has given some 50,000 rupees to B. 3 years is gone. B is not ready to pay the amount. 3 years, 4 years is gone. But before completion of 3 years, one letter was issued by Mr. B to the brother of Mr. A. That I am not having money, મારી પાસે અત્યારે પૈસા નથી, હું આવશે ચોક્કસ આપી દઈશ, તમે તમારા ભાઈને સમજાવજો. Likewise, there is an admission. So from that ground, some 3 years may other be benefited for going to the court. So this is a limitation. A limitation, when the suit is barred by limitation, then there is no remedy. There cannot be application under delay condon application can be given along with the suit. Delay condon application under section 5 can be given for any petition application or for any appeal, but it is not applicable to the suits. That is also to be remembered. Some legal provisions for your argument in any case. So on this ground, some benefit can be available to the appellant or either to the defendant as the case may be. Now, when the suit is filed, then it is numbered and registered, then a notice is issued or the summons to be issued to the defendants to appear and to reply on a particular date as may be fixed by the court. This is the first stage. And there is a procedure under Order 5, issue of the summons, issue of the notices through the bailiff or by this electronic media, by newspaper or by substituted services of service on the conspicuous part of the premises of the defendant if he is not available. All this procedure is completed, and then suppose that defendant presents before the court, then file the WS, written statement, written reply. When the written reply is filed, then on the basis of written reply, the plaintiff will try to give explanations for wrong statements, wrong allegations made under written statement, and can make some other affidavit, and they will deny the allegations which are made in the written statement as like a counter claim. Then after completion of everything on documents, then the matter will be partly ready. If in between some miscellaneous application or some injunction application, that all will be decided. After deciding this, from the ready material before the court, that plaint, written statement, documents, other affidavits and everything, nothing is now required to be submitted by either of the party, then the matter will be taken on issues. Prior to that, some application for preliminary issue can also be made by the parties, particularly the. So when the issues are required to be framed, at that time, every material on which the plaintiff and the defendant they realize, it is already submitted to the honorable court. So from the materials, the court will come to the conclusion that which fact or which issues are required to be made. And prior to making the final issues, as I told you, that there may be a preliminary issue on question of law, and that may be a limitation, that may be on a judicial point of view, and prior to that, about the Order 7 Rule 11, the application for rejection of the plaint at the earlier stage can also be filed, and that point can also be considered afterwards. That depends upon the discretion of the court. Now, the issues may be either preliminary, it may be final. Now, the final issues can be framed by the court by taking the proposed issues from both the party, either of the side, they will submit the issues, and after that the court on hearing will finalize the issues on which the evidences are required to be leaded by both the parties. And after leading the evidences from one side or that side, the witnesses of the plaintiff are examined, witnesses of the defendants are examined, and nowadays the affidavit under order 18 or 19 that can be submitted for the examination of the chief along with the documents, so that the time of the court can be saved. So after the witnesses are examined from plaintiff side, on the defendant sides, then the closing process or the no further evidence is required to be taken in this matter, and then the evidences are closed. Afterwards, the plaintiff or the defendant both have to give the written arguments or the oral arguments, and basing on the citations or the case laws on which they rely, and then the judgment follows. So this is what we can say the procedure about a suit. Now after this decree is passed, then the darkhast can be filed to the proper court having the jurisdiction under order 21 of the Civil Procedure Code. So this is what the procedure. And when any prohibitory order or any mandatory order is given by the court, then it must be followed by the other side, failing which the contempt application can also be taken by the court. That is what.